Dear participants, a very warm welcome to this lunch webinar. I'm Professor Pascal Pichonnat from the University of Fribourg in Switzerland, and as President of the European Law Institute, it is my great pleasure and privilege to welcome you all to this webinar dedicated to assessing the impact of the KlimaSeniorinnen case on the climate change policies and litigations in Europe. On the 9th April 2024, the Grand Chamber of the European Court of Human Rights delivered a seminal judgment in the case Verein KlimaSeniorinnen Schweiz and others versus Switzerland, which we will refer to as the KlimaSeniorinnen case later on. This case spurred an avalanche of polarized commentaries from those claiming that the Strasbourg court interferes too eagerly on climate policy making, to those announcing the arrival of a new area in climate change litigation. Even the Swiss Parliament took a rare official position on this case by officially rejecting the ruling on 12 June 2024. It is of course not clear what this means concretely, but it shows the importance of the case as such. One umbrella of the European Law Institute's projects deals with climate justice, environmental law challenges, and sustainability. Under this umbrella, we launched a project in 2021 entitled Climate Justice, New Challenges for Law and Judges. And therefore, as a voice of the legal community in Europe, the ELI felt as a duty to organize this roundtable to better understand and assess the impact of the KlimaSeniorinnen case. To that end, we have a fantastic panel today. I will present them once they will speak, but let me nevertheless greet Professor Véronique Boyer, Professor of Law at the University of Lausanne, Luca De Carli from the European Commission's Directorate for Climate Action, Judge Matthias Keller, co-reporter of the ELI Climate Justice Project and Judge President at Aachen Administrative Court, Kerem Altıparmak of the International Commission of Jurists, and last but not least, Robert Spano, former president of the European Court of Human Rights and partner at Gibson Dunn. Before starting, let me also remind you that we await your questions. Please use the Q&A function at the bottom of your screen, and we will then answer those questions orally after the first round of presentations. So let's start now with Professor Véronique Boyer. She's a professor at the Law School of the University of Lausanne and member of the board of the Swiss Institute for Human Rights. Her field of research deals with the European and Swiss constitutional system, on which she published numerous articles since 2017. Her current interests include the principle of non-discrimination and the links between the environment and human rights. She will now present us the link between the judgment and the Swiss democratic system and the questions relating to its implementation. Véronique, you have the floor.
Thank you very much. Thank you very much for the invitation. I'm very happy to take part in this webinar. I would like to come back, as you mentioned, to the two following issues. The link between the judgment and the Swiss democratic system and the implementation of the ruling, particularly with regard to the violation of Article 8 of the Convention. As a Swiss scholar, I consider that it's not only within my area of expertise, but also my responsibility to monitor the implementation of this ruling. As you probably know, this judgment finds that Switzerland has violated Article 8 of the Convention because it has not adopted sufficient measures to achieve a significant and progressive reduction of its greenhouse gas emission levels in order to reach net neutrality over the next 3 decades. The court underlined in paragraph 549 that immediate action needs to be taken and adequate intermediate reduction goals must be set for the period leading to net neutrality. Such measures should, in the first place, be incorporated into a binding regulatory framework at the national level, followed by adequate implementation. The relevant targets and timelines must form an integral part of the domestic regulatory framework as a basis for general and sectoral mitigation measures. The judgment and in particular these instructions were, as was mentioned by Professor Pichona, particularly badly received by politicians in Switzerland, who argued that the judgment undermined Swiss democracy. The two chambers of the Swiss parliament issued a declaration stating, among other things, that the court had not respected the principle of subsidiarity and had gone beyond its power of interpretation. The parliament then invited the government to inform the Committee of Ministers that Switzerland will not be taking action on the judgment and that the court must respect the democratic process of the member states. I think it's important to focus on these points. First, as regards respect of the democratic principle, it is very interesting to note that the court anticipated the problem by expressly recalling in its judgment at paragraph 412 that democracy cannot be reduced to the will of the majority of the electorate and elected representatives in disregard of the requirements of the rule of law. The remit of domestic courts and the court is therefore complementary to those democratic processes, and the task of the judiciary is to ensure the necessary oversight of compliance with legal requirements. This is also the case, in fact, at national level. The Swiss courts, particularly the Federal Supreme Court, also have the duty of ensuring that fundamental rights are respected, whether in relation to the administrative authorities, parliament, or the popular will. Emblematic judgments have been given in Switzerland, for example, on naturalization by the people. Turning now to Switzerland's refusal to comply with the judgment, I think it's important to recall the process set out for this. Following a judgment, the Committee of Ministers invites Switzerland to inform it of the measures it has taken and or intends to take in response to the judgment as soon as possible. A dialogue then takes place between Switzerland and the committee, whose secretariat can assess whether any action is necessary. If the implementation process encounters difficulties, the Committee of Ministers has, I would say, 4 options at its disposal. Firstly, Article 46, paragraph 3 of the Convention provides that the committee may refer the matter to the court if the execution of a final judgment is hindered by a difficulty of interpretation. To my knowledge, this procedure has never been used in practice. The committee may also adopt interim resolutions to assess the progress of implementation, express its concern, or make suggestions concerning implementation. Article 46, paragraph 4 then sets out a procedure for non-compliance with a judgment. So it's the committee and the committee only that can refer a case to the court after giving formal notice to the state concerned. To date, this procedure has only been used twice. And finally, suspension or even exclusion from the Council of Europe may be considered, but it's obviously an ultima ratio. So in my view, it seems very unlikely that this tool will have to be used against Switzerland, because an analysis of the implementation of the court's ruling in Switzerland suggests that in principle, Switzerland implements the ruling seriously and promptly. Nevertheless, the statement made by the Swiss Parliament are highly problematic, because they call into question the legitimacy of the courts and judicial review in general. They imply that the court has engaged in a judicial activism, even though it has a rich body of case law in environmental matters to support such a conclusion. They imply that the court is undermining the democratic process when it is the judge's responsibility to ensure that the decision of all public bodies, including the people, comply with human rights. And finally, they suggest that the court is undermining the separation of powers by dictating climate policy to the Swiss parliament, even though the court emphasizes that parliament has big discretion when it comes to choosing concrete measures. On this last point, I think it is important to point out that if Switzerland does decide to implement the ruling, the process will be particularly complex. It is clear that an entire system is being challenged here. It will therefore involve difficulties related to federalism. For example, the federal, the cantonal, and the communal authorities will be affected by the implementation, and coordination and information transmission problem will inevitably arise. There is also the question of how to evaluate the measures taken. Will the Committee of Ministers have the necessary competence to determine whether Switzerland has taken sufficient measures? And will the other member states of the Committee of Ministers, who are all affected by the ruling, support ambitious implementation? That's a question I ask now, and I will end now my introductory remarks, and I'm looking forward to continuing the discussion with you and the other member of the panel.
Thank you very much, Professor Boyer, for this very clear presentation of the implementation and what faces the proper implementation, but also the difficulties, especially with a federal state like Switzerland. But of course, Europe has other federal states which have probably also similar difficulties when some issues are dealt with on several levels, like this is the case, for instance, for Switzerland. I suggest that we continue now our round table, so to say, with Luca De Carli. He works in the European Commission's Directorate for Climate Action, where he leads the unit dealing with legal affairs and interinstitutional relations. He is also responsible for the European climate law and its implementation. Prior to working in DG Clima, Luca De Carli worked in the Commission's Trade Directorate, working on strategy and on legal issues. He was the EU negotiator for the dispute settlement provisions of several agreements, including the WTO dispute settlement understanding. And we asked him to bring us the view from Brussels, the KlimaSeniorinnen case seen from Brussels. What is the impact on EU climate policy from that ruling? And you have the floor. Okay.
Thank you very much, Pascal. Yes, you remind me of the DSU and the WTO appellate body, where there's 20 years discussion on whether there's judicial overreach and what is the correct standard of review of international tribunals. So from Brussels, we had our own case going on, the Portuguese kids, which instead was not successful on standing because the court found that they did not exhaust local remedies. They were admitting it from the very beginning. And so then we read with interest the Swiss case to see, first of all, two questions. One, would we comply with the standard set by the court, knowing also that our own Charter of Fundamental Rights is cut and paste from the European Charter of Human Rights and should be interpreted the same. So we have quite a stake in seeing what is the interpretation given of the Charter. And two, okay, what does it mean for our policy? In terms of the standard, we are quite happy with the standard set of saying that human rights, rights to life, rights to a healthy environment includes a right to see your climate protected. Because definitely the amount, the size, the severity of climate change is existential to us as humans. And so seeing that having this right protected is the right reading. Second, where did the court put the bar? We very much underlined and colored this discretion that a state has, but also the framing we think is very coherent and very appropriate. What do you need to do? You need to have a long-term strategy. That's the Paris Agreement. That's what we're telling every country. We do have one. You need to have intermediate targets that are coherent, laws that enforce them, and laws that are coherent with the achievement of these targets. This coherence aspect is also very much to us. Unfortunately, Switzerland found itself in the position that the 2030 target was annulled, and so they had to fall back on 20. For us, we have a 2030 target, which has been actually increased. We just finished all the legislation to implement it. The course also talks about the importance to an adaptation strategy, so to help citizens coping with the climate which is already happening. Again, we just put the accent. So we were confident we can comply with the ruling if it was applied to us. We are happy, I think, with a somewhat conservative approach to the standing. You know that the European Court of Justice is also quite strict about standing. We think it's correct because my job as commission, so if you want government or working with the legislators in council and parliament, we think you need to keep a little bit of institutional balance between the judiciary and the policy makers. And we see that more we are engaged in climate action at these times where the targets become very ambitious and the need for change becomes very high, you come into trade-offs very quickly. Do you want to push your energy sector, or do you want to push the industry sector, or the cars, or the housing? And you have to push everyone, but at what time, at what speed are you ready to put the burden on citizens to renovate the housing? With what money? What is the social policy you do with it? And so there is a lot of political consideration beyond saying we need to do more for the environment, which belongs, I think, to the policy makers. And so from our reading, we are quite comfortable with the court saying, you have to do something, this is more or less what you should do, but you have a margin of discretion. It's also the ITLOS case, a couple of weeks after, also they don't say margin of discretion, but they give you a bit of margin to see how you embody this right into your climate action. So from us, we welcome the reading. We think we comply. We think it's the right separation between parliaments and court. And to be honest, we think Switzerland can also comply. They're committed to climate neutrality. They will have to show up at the next COP with a new target, with a new national determined contribution by next year. Half of the Swiss emissions are part of our emission trading system. They can comply. Of course, it's a very interesting legal issue, which we're here to talk about, but in the practice, I'm confident that Switzerland will maintain a very adequate climate policy. Thank you.
Thank you very much. So listening to you, it appears that the court did everything right, which is really interesting also in terms of, setting the bar and what is feasible then for states, or in particular here for the EU. Very interesting. I'm sure we will come back in the Q&A sections when we will have also to answer questions from the public. Let's continue now with Matthias Keller. He is a presiding judge at the Administrative Law Court in Aachen, and he holds a doctorate in administrative law from Würzburg University and has been a judge mediator in administrative disputes since 2006. He's a fellow of the European Law Institute, a founding member of the German branch of the Association Henri Capitant, and an expert on EU environmental law. He has also co-authored several legal texts, including EU-Recht in der Praxis and Justiz und innere Sicherheit im EU-Recht. But if he's here, it's not only because he's an expert in the field of environmental law and an administrative judge, but also because he's one of the co-reporter of the ELI project on climate justice, which is all about mainly about the right to stand, and therefore also some aspects that have been risen by the court. So he will explore now the impact of KlimaSeniorinnen versus Switzerland by putting it in conversation with Neubauer versus Germany. Matthias, you have the floor.
Thank you very much, Pascal. It's nice to be here. But first, a personal remark. Don't underestimate the Swiss team, because I'm speaking as a German. We had a tough football game yesterday, and don't underestimate the Swiss policies on climate change. There's so many good things that we shouldn't forget that in the drama of or in the context of this ruling. So I would like to put this in perspective also with the German experience, Neubauer, and then you will see, hopefully, the situation is not as dramatic as we might think. First of all, we have common ground. We all suffer under temperature rise, and we all see the problem of human-induced emissions of greenhouse gases. We all have the commitments, almost all states committed themselves in the Paris Agreement. And we are on the way, we are on a common way to net neutrality till 2050 as regards Switzerland. So the only legal question here is, what happens if climate laws are not fit for purpose? That's the legal question. And here we have already the landmark Dutch agenda ruling. We have the German Neubauer decision, and now the KlimaSeniorinnen judgment from Strasbourg. And they all send a very clear message to all of us. Insufficient climate laws are indeed a violation of human rights. And there is this development in legal orders that was already predicted by Peel and Ozovsky, and it was framed as a human rights turn, a rights turn in climate change litigation. And that's, I think, the starting point. And then we have to work with this human rights turn. And a practical question is, who has standing? Who has locus standi? Who has the victim status? Speaking in the parlance of the convention under Article 34. And there is a very strict individual standing, as mentioned by Luca De Carli. I'm not so happy with that, but however, it's a very strict individual standing for the KlimaSeniorinnen as persons. And the meaning is, here there is a very small impact. You already have a very strict individual standing, and you can keep that. But now we have the surprise. There is a new approach to NGO standing. And this approach is breathtaking. So NGOs are the biggest procedural winners of this case, and Switzerland must guarantee a better access to justice for NGOs in climate litigation. There is no alternative, I would say. Coming back to Germany, in Germany, it was the opposite. There is a big scope for standing, or there is the Federal German Constitutional Court was granting individual standing for young persons. They can claim intergenerational equity, but not, that is often forgotten, not for NGOs. Sorry for my words, but the NGOs were kicked out of the procedure. That's very interesting to realize. Well, this is standing, and this is admissibility of judicial review. On the merits, I'm very much in favor of the ruling when it comes to the merits, but because it relies on existing case law in the field of environmental cases. So you have all these cases, industrial pollution, etc., name it, waste disposal, name it. And then the court says, well, there is a positive obligation to protect individuals from serious effects of climate change on their life, health, well-being, and quality of life. This is convincing. And then the court can rely on a well-established structure. you have this positive obligation, and the states have a wide margin of appreciation when fulfilling this obligation. And of course, I mean, I'm an administrative judge, no discretion is endless. So there are legal limits to a margin of appreciation, and this legal limits must be object to a court review. For me, this is self-evident. And the court even has a practical approach. He said, we'll give you some hints as to this legal limits of the appreciation. And he names in paragraph 550, he names 5 requirements: carbon budget, intermediate reduction targets, provide evidence showing that duties are duly complied, and there should be a relevant updating process of the targets. And of course, everybody should act in good time. Hopefully, I'm acting in good time as well. But let me just make a last remark, and switching again to the German approach of the matter. And in the Neubauer approach, the approach was not on positive obligations, but the German court established an interference in climate litigation, an interference of the legislator with future freedoms, fundamental rights over time, future freedoms of life, liberty, and property that in the words of the court, have an advanced interference-like effect, and therefore must be reviewed as an interference. I find the Strasbourg solution more convincing and drawing on positive obligations. Thank you very much.
Thank you very much. Sorry. Thank you very much for this perspective that puts indeed the decision in a different light. And I really look forward to the discussion again, because I think we are getting more and more pieces of the puzzle together, and that will be certainly interesting. So that's why we need now to go a step further, if I may say so, and that's with Kerem Altıparmak. He's a senior legal program consultant, has a law degrees from the Ankara University, a PhD degree from Leeds University. He was the director of the Human Rights Center of the Ankara University until October 2017. He won several prestigious awards, including the Columbia Global Freedom of Expression Award in 2016, the Turkey Press Freedom Prize 2016, and he received the Franco-German Prize for Human Rights and the Rule of Law in 2017. And Kerem will now present the implementation of the KlimaSeniorinnen judgment, and especially its erga omnes effect, which is, of course, very interesting too. So please, Kerem Altıparmak, you have the floor.
Thank you very much. I'm representing International Commission of Jurists here, but coming from a jurisdiction where implementation is a big problem, like in the Kavala and Demirtaş judgments. So it's exciting to talk about another jurisdiction now where implementation might be a problem. As you stated, there are 2 aspects of this implementation. One of them is an inter partes, and we've talked a little bit on this. Because Article 46 states that the judgment is binding for the state party to the case. And indeed, in this case, the applicants ask the court to impose individual and general measures upon the state parties. And here is how the court responded. The court reminded that in certain cases, the court has found it's useful to indicate the type of measure, individual or general, that might be taken to put an end to the situation, which has given rise to the finding of violation. In this case, the court said, in the light of the complexity and the nature of the issues involved, the court found that it could not be detailed or prescriptive as regards any measures to be implemented in order to effectively comply with the present judgment. And the court left this discretion to the Committee of Ministers. So the government, as already noted by Professor Boyle, is better placed to work with the government on this. However, when we look at what the Swiss government is required to do, not only the operational part of the judgment, but the obiter dictum, the reasoning of the judgment is critical. In that way, we can find both what the Swiss government should do and what other governments party to the convention should do. The court stressed that it is only competent to interpret the provisions of the convention and its protocol, but also it noted that in line with the international commitments undertaken by the member states, most notably under the United Nations Framework Convention, Paris Climate Agreement, and in light of the compelling scientific advice, particularly by the Intergovernmental Panel on Climate Change, state needs to put in place the necessary regulations and implement them. So for the first time, as already noted, the European Court entails positive obligations for states in the context of climate change to adopt and to effectively apply in practice regulations and measures capable of mitigating the existing and potentially irreversible future effects of climate change. So when we look at the obiter dictum, we see two things. What did Switzerland do and failed to meet the requirements of the convention? And what should Switzerland do? Because those two questions give us a clue for other states as well. First of all, Switzerland, with the currently existing 2011 Carbon Dioxide Act, required that emissions reductions of 30% by 2020 compared with 99 levels. But the requirements for 2050 should be between 50 to 85%. And as the government acknowledged, domestic assessments found that even the reduction target for 2020 had been missed by the Swiss government. And a proposed revision for the act, an overall reduction of 50% emissions, was rejected in a popular referendum in 2021. So what should Switzerland do? The court makes a distinction between two types of margin of appreciation in climate change cases. The court says that the first one is the state's commitment combating climate change and setting objectives in this respect, and the choice of means designed to achieve those objectives. The margin is much more narrow with regard to the former. So all state parties is under the obligation to combat climate change, but their means might change according to the court. And as already noted, in paragraph 550, the court set out the criteria it will use to decide whether a state has remained within its margin of appreciation, namely whether the authorities had due regard to the need to adopt general measures specifying a target timeline for achieving carbon neutrality and the overall remaining carbon budget for the same frame, set out immediate greenhouse gas emissions reduction targets and pathways, this is critical, by sector or relevant methodologies that are deemed capable in principle of meeting the overall national greenhouse gas reduction goals. Provide evidence showing whether they have duly complied or are in the process of complying with the relevant greenhouse gas targets, and keep the relevant greenhouse reduction targets updated with due diligence and based on the best available evidence. As already stated, the Swiss Parliament asked the Swiss government to inform the Committee of Ministers that there is no reason to give further effect to the court's decision, given that its past and current climate policy efforts meet the human rights requirements set out in the ruling. This part shows, the obiter dictum shows that this does not reflect reality. So although the court did not impose clear general measures to be adopted by the Swiss government, it put the measures which needs to be adopted to end the violation decided in the judgment. And whether this decision also imposes obligation upon other states, as I stated, Article 46 has an inter partes effect, so is binding for Switzerland. But we know that 6 other cases are pending before the court, brought against different member states. So I guess that they will be decided in near future. So there will be other state parties possibly to implement similar measures to meet the requirements of the convention, but also ergamness of the effect of the judgments and the res interpretata effect of the judgments should also be considered in climate change cases, because we're talking about 46 member states waiting, all of them taking measures to implement the requirements of the convention. After the court decides against them, would be against the spirit of the convention, as well as the principle of subsidiarity, because now all national judicial authorities are under the duty to implement the convention domestically according to this subsidiarity principle as explained in Protocol 15 of the convention. So the principles that I already stated should be seen as a binding guidance for other member states. So I think this judgment, more than any other judgment, has impacts on all member states and requires them to take measures to comply with the convention and other international treaties. Thank you.
Thank you very much. Thank you very much also for putting that in a broader perspective. And we will probably come back on the standards and the margin of appreciation, because of course, as soon as someone says it has an erga omnes effect, the question is really to what extent. And as you rightly underlined, the margin of appreciation might be different from one to the other question, and also the limits are not, of course, are to be set, and the court tried to do it. We will now continue our journey around these different approaches and thoughts with Robert Spano. He's a former president of the European Court of Human Rights. He was the youngest judge ever to be elected to the presidency in the court's 60 years history, but at some point he had also to retire from the court. So he's now a partner in the London and Paris offices of Gibson Dunn and member of the firms Transnational Litigation, International Arbitration, Environment, SEG, Privacy, Cybersecurity and Data Innovation, Technology, Regulatory and Litigation. I think they might have a short branding name for the practice group, but at least he's member of this practice group. And of course, he bridges unparalleled experience from senior roles in the judiciary, private practice, and of course, academia as well, because he has been, before being on the court, also a professor in Iceland and still teaches, so far as I know, here and there. And that's why I look really forward to what he has to say now as main takeaways of what he calls trilogy of ECHR climate rulings, KlimaSeniorinnen, Duarte Agostinho, and Carême, and the future of European climate change litigation against states and corporates in the light of these rulings. Robert Spano, you have the floor.
Thank you very much, Pascal. Happy to be back at the European Law Institute. Let me first start with three sort of preliminary points, which I think are which I consider important for this debate. The first is that human rights law, as such, is not a particularly suitable or useful vehicle for this debate. And that may sound counterintuitive from the former president of the European Court of Human Rights, but let me explain that in a moment. The second preliminary point that I want to make is it is very important to view KlimaSeniorinnen along with the other two cases that were decided on the same date. And this, of course, I know because I was president of the court when these cases were processed before the Grand Chamber. I picked randomly the judges who sat on these panels and the rapporteurs for these cases, and I know intimately what the idea was. In other words, it is clear that it's not a coincidence that they were heard at the same time and they were decided pretty much at the same time. To the first point, the problem sometimes with difficult societal issues and policy issues is that human rights law can be quite a binary legal discipline. It is often a discipline where answers are viewed as right or wrong. I think coming back to what Luca De Carli said, which I think is crucial, the issue of climate change is not a binary human issue. It is not good or bad. It's not black or white. So when policymaking is performed in the human rights space when it comes to climate change, there are other considerations: energy transition, energy security, the distribution of limited public resources that are crucial for an overarching view on how climate change can be dealt with. So therefore, findings by international courts composed of international judges who have potentially limited insights into the difficult equations that come into play when policy in the climate change space occurs can create challenges. And that's why I think, moving to my second preliminary point, I think one has to view the KlimaSeniorinnen judgment, Duarte Agostinho and others, 32 other against Portugal and 32 other member states, and Carême versus France, as a trilogy of cases which in general demonstrate quite, I would say, not a large step, a first step by the European Court of Human Rights that I feel that sometimes in the debate has been exaggerated. I fully ascribe to Luca De Carli's view on the overarching view of the case. I also think Matthias Keller has adequately demonstrated the positive elements and the salient elements. Those are the preliminary remarks. Then I want to make three further remarks which are more in substance. The first is a technical one, which deals with standing. It must be borne in mind when those that applaud the judgment say it as and consider it a landmark. It must be realized that the European Court of Human Rights effectively excludes individuals from being able to demonstrate victim status and standing. Now, that is, of course, a very, very big decision on behalf of the European Court of Human Rights, and is one which, of course, is not a victory for those that consider that the court should be an open avenue for climate change litigation. On the flip side, what the court takes away with one hand, it gives back with another. And that is the great expansion of associational standing, which Matthias Keller mentioned, and which is unprecedented. Ultimately, Article 34 of the Convention is clear. the claimant, the applicant, needs to demonstrate victim status. Victim status is a preliminary jurisdictional threshold to be able to access the convention system. Without victim status, you are in fact opening up an actio popularis. Now, what the court says when it comes to associational standing, after having first rejected the individual submissions, says that an association which fulfills a certain number of criteria, which are rather easy to fulfill, do not have to demonstrate. In other words, associations do not have to demonstrate that their individual members, each of which are members of the organization, could in and of themselves individually demonstrate victim status. That, in my view, is a first. That in fact means that there is no application before the court where the applicant has victim status. Now, that I think is probably the biggest takeaway when it comes to future of climate change litigation in Europe, because it will open up, and I think this will require several member states of the Council of Europe to alter their procedural mechanisms for when it comes to associational standing in cases where it is difficult to foresee that individuals have standing themselves. Second point of the three that I want to mention is the way in which the court drives home the message that the European Court of Human Rights will not be the first instance climate change court of Europe. And that's why it's important to look at Duarte Agostinho and Carême at the same time. The very robust approach taken by the court in Duarte Agostinho vis-a-vis the requirement for the individuals, the children in Duarte Agostinho, to exhaust domestic Portuguese remedies before they go to Strasbourg. Their argument was, this is a global issue, this is a transboundary issue, therefore each individual jurisdiction is non-effective for the purposes of the convention. This was rejected by the court. Moreover, the court rejected the extraterritorial jurisdictional claim made by the applicants in Duarte Agostinho. This is a big decision as well, refusing to view climate change emissions as a cross-border issue in the sense that states have extraterritorial jurisdiction attached for emissions outside their jurisdictions. But again, what the court gives with one hand, it takes away with the other, because there is an embedded question in the judgment, and that's the question of embedded emissions, which the court accepts does fall under the positive obligations of states under Article 1 of the Convention, which means for Switzerland, embedded emissions account for about 70% of their emissions. So that means embedded emissions are emissions which are produced when in imported goods that are imported into Switzerland, not by emissions within Switzerland itself. This is a huge counterbalance to the extraterritorial issue. Final point that I would make, Pascal, before we head into Q&A, and that's the following issue. Climate change litigation in Europe has two dynamics. On the one hand, we can call it the public enforcement model. That is, NGOs, mainly NGOs, but individuals as well, are suing states for violations of their international law obligations, and sometimes even obligations of the executive under national laws. For example, the recent judgment of the UK Supreme Court in Surrey County Council, which deals with the interpretation of the environmental impact assessment legislation for climate emissions. The other model, which we haven't discussed today, is the private enforcement model, which means individuals and NGOs suing corporates, who are, of course, corporates are the main emitters of climate change materials. My view is, there is a misconception ongoing, that the European Court of Human Rights judgment in KlimaSeniorinnen opens up a further avenue or strengthens the position of NGOs vis-a-vis corporates. In other words, horizontal application of convention requirements. And the main reason for that is the court's view as to standing when it comes to individual rights for the purposes of the convention. The main vehicle for private enforcement in national jurisdictions has been tort law, where tort law has been leveraged with infusing human rights law related obligations and into creating liability regimes for corporates. For example, the Shell case in the Netherlands, which is now before the Court of Appeal, in my view, there is nothing. In fact, on the opposite, the European Court of Human Rights judgment in KlimaSeniorinnen actually limits the scope of convention provisions when it comes to horizontal application of convention law in the climate change space, because it effectively excludes individual rights or victim status, which is, of course, the basis for any tort-based liability. So these are my main takeaways. There's a lot more to say about this. Thank you very much.
Thank you very much, Robert. I think you put the point, obviously, on very important points. And for the Q&A section, we got already a couple of questions by Izzat Hussar. But I wanted to ask a first question, because that's exactly the point you mentioned, the distinction between vertical climate litigation and horizontal climate litigation, because I have the impression that, as you said, the KlimaSeniorinnen case is very important on the locus standi, and the fact that individuals were excluded might give the impression, at least, that horizontal claims will be more difficult. Is it really so? In the sense that maybe the access to the European Court of Human Rights will not be possible. But do you think that this will have an impact on locus standi, on domestic litigation, horizontal, I mean, litigation, or will the impact only be on the type of substantive arguments that can be brought by these individuals?
If I jump in, I think
yes,
I think to qualify the question is as to the latter. I think it limits the scope at national level for claims based on the European Convention on Human Rights before national courts. Of course, there are different standing requirements at national level in relation to the different type of substantive claims. But the KlimaSeniorinnen judgment does teach us that when it comes to convention claims in human rights, in climate change cases, when, for example, claims are made for liability against corporates using open-ended due diligence requirements under tort law, and they are infused, the claims are infused by convention requirements, Article 2 and 8, like was done in the district court in Shell, like it's now pleaded before the Court of Appeal. Well, how does the tort claim, which is supposed to be reinforced by obligations transpiring from the convention, how is that substantiated when under KlimaSeniorinnen the individual claimants do not have victim status to bring those claims? Mm-hmm. So whether that applies more broadly, that's not for me to say. That is for national lawyers dealing with individual spheres of substantive law and tort law. There may be tort law principles which will open that up, but when it comes to the convention, individuals have very scant victim status to bring such claims.
Thank you very much. This is very clear. I will ask maybe now a further question to Matthias Keller, because a couple of months ago, the first president of the French Cour de Cassation, Christophe Soulard, wrote a piece in the ELI newsletter, in fact, on the rights for fundamental rights for future generations, and the whole issue of standing of future generation as such. How would you say that this is to be considered in light of KlimaSeniorinnen and in light of this locus standi issue? Would that be a different perspective? Because that has been mentioned by a couple of you.
Yeah, thank you very much. Yeah, I think KlimaSeniorinnen is, it's my impression, a bit weak on intergenerational equity, especially if I compare this to the German Constitutional Court. For the German Constitutional Court, intergenerational equity was the main focus for its human rights approach. And the German Constitutional Court, they even developed their human rights doctrine and said, well, human rights, they have a time dimension. So human rights have to be guaranteed over time, meaning we're looking only at young people there, and we are safeguarding their enjoyment of human rights in the next decades. I mean, the situation for the Strasbourg court was different. The claimants were elderly women, so perhaps this idea was not the first idea, and it sounds a little bit cynical, but when the KlimaSeniorinnen if they had made their claims at the German court, well, the German court could not even have developed this idea of rights over time in the next decade. So intergenerational equity, I don't see very much in KlimaSeniorinnen.
Mm-hmm. Indeed, yeah. Thank you very much. I see Kerem Altıparmak.
Yeah, a short comment about this individual victim problem. 2 years ago, the UN Committee on the Rights of the Child in Saki et al. Versus 6 other states found application inadmissible, but only on the grounds of exhaustion of local remedies. So the victimhood of children were accepted by the committee. And I know that some people initiated new legal proceedings before relevant states, and there was a chance to go to the European Court of Human Rights after the exhaustion of local remedies. Then it seems now that the only way for people to go is UN committees, especially for children. Maybe for other people, it might be different committees at the UN. But it seems that it became quite difficult for individuals to approach to the European Court of Human Rights after they exhaust local remedies, even for children. So I think it will affect the pending cases, this locus standi discussion before the European Court of Human Rights.
Mm-hmm. Thank you very much. Yeah, indeed. And as was mentioned, it may have even an impact on how to set the locus standi on domestic level. Like in Switzerland, we would have exactly the opposite way, right? And indeed, that's how it was mentioned both by Matthias, I think also by Kerem and by Robert Spano. This is probably the most important change through this KlimaSeniorinnen is really the fact that as an organization, an NGO, you do not need to show that your members have been affected. And even if you are affected as individual and potentially be able to show that, that would probably not be sufficient to come with such a claim. So how do you see that, Véronique Boyer? Because you're in Switzerland and you are following, and you know also that there's now a horizontal case in climate case on green gas in the canton of Zug against one large company. Maybe that might also play a role. How do you consider that?
So it's clear that it's a question now before the local and the national authorities. I have the feeling that the KlimaSeniorinnen case will have an impact of the standing of the associations because of the judgment. So because it's clear now that the associations don't have the locus standi at the time now, and I don't know if the lawyers are going to try to modify the judgment itself, because there is a local procedure that permits the lawyers to ask to change the judgment and the results so that they can start again from the beginning. And I have discussed with the lawyers, and I'm not sure they're going to try this way. But when we discussed the KlimaSeniorinnen cases with other colleagues that are thinking about the impact, it's sure that the locus standi of the association will be something, but politically, that's another question, because we already saw that in your field, so in the consumer fields, there is now the parliament that are talking about the rights of the association of consumers to go to the courts, and the political will was to change his mind because of the fear of giving too much weight to the association. And in other political processes that are now in front of the parliament, there are a few trends that show that the political really want to reduce these rights. So it's a case in a so agriculture products. They are trying to reduce the possibility of the associations to go and attack decisions. So I'm not sure. So it's always the question of the judicial aspect and the political impact, because now in Switzerland, there is really a trend that shows that the political wants to reduce the right of the associations. So maybe it won't be very productive. In fact, in climate change, it won't be possible to go against the judgment. So the judges of Switzerland will have to respect the judgment. But in other fields that are now in front of the parliaments, it's not so sure.
Yeah, thank you very much. And indeed, in Switzerland, the economy and the majority of the parliament is probably against expanding the collective rights claim, kind of European representative actions in Switzerland. There's a proposal, but it is clearly very difficult to get it through. And therefore, there's a kind of important tension between this domestic perspective, which is more focused on individual rights for good or bad reasons, and a more collective approach that is promoted by, and for well understandable reasons, it seems to me, by the European Court of Human Rights, saying, okay, we don't want an actio popularis, but at the same time, we don't want to be facing hundreds of thousands of claims by people. And here we have a question by Ivanka Antova. She says, and it's more directed to Robert Spano, whether he could expand on how the Swiss case offers a counterbalance to the court rejecting the extraterritorial and transnational arguments in the Portuguese case. Whether here there is something to say, Robert.
Yes, I think as I mentioned, one of the transformative claims made by the applicants in Duarte Agostinho was that climate change was a cross-boundary, transnational, global issue. And therefore, even though they were under the territorial jurisdiction of Portugal as being residents of Portugal, they were in a position to, with their application, to attach jurisdictional status or trigger jurisdiction to other 32 member states of the Council of Europe. This would have required the court, for those of you on the call or in the group that know the extraterritorial jurisdictional doctrines of the European Court of Human Rights, that would have required the court to carve out another exception to the general rule that jurisdiction under the convention is primarily territorial. There are only two exceptions that have been accepted. Those are mainly dealing with effective control over areas where states occupy as a matter of international law, and then is what is called state agent authority and control. So this would have been a special climate change exception. This was refused. What the court, that, however, does in KlimaSeniorinnen, it confronted the issue, what should be the scope of the positive obligations under Article 8 when it comes to the nature and scope of the emission process. Emissions can be produced or emitted within the territorial jurisdiction of the state by factories or other types of operations, but they can also be they can also be embedded in the sense of being emissions which are created in the production process of imported goods. And what the court did, which I think is a counterbalance, is while the court said in Duarte Agostinho, no, there is no extraterritorial jurisdiction when it comes to climate emissions. The concept of jurisdiction will however, take into account the embedded emissions of the state, the territorial state in question. So that, for example, for a state like Switzerland, which has limited, well, compared to many other states, a limited local production of emissions, but quite extensive import of emissions, that of course does create a bit of an extraterritorial flavor to the concept of emissions that is used for the purpose of jurisdiction. So as I said, the three cases are a trilogy. One has to look at all three of them to understand each and every one of them. And that's, I think, very important. And it's something I'm afraid that some commentators have missed when they are reviewing these judgments, only looking at each one of them, but not viewing them as a whole.
Thank you very much. Very, very clear and very, very useful indeed. I see there's another question on corporate liability and whether it can be reconciled with the existing emission trading system in Europe. And maybe I turn to Luca De Carli, because of course the European Union has now, taken on a number of initiatives also in terms of compliance, due diligence, and so on, linked to these issues. And do you see a specific impact, or let's say an indirect impact from KlimaSeniorinnen or the trilogy of cases on these aspects, and especially on these ETS?
No, on this, as Judge Spanol was saying, I think it's very limited, the impact. So of course we regulate the transparency because we see due diligence, but wouldn't read into this due diligence obligation the tort due diligence that, you drink a drink and there is a mouse inside the bottle, and from there, therefore, you have a duty to protect. In fact, when I was saying, the right balance between court and legislators, I was thinking, for example, about Uganda, where instead you have the court that decides exactly what is the percentage amount that the Dutch government has to reduce emissions from, and where do they get it? From the reading of the Paris Agreement and the IPCC report. So I welcome the fact that there is a human rights obligation to do something about climate, that the something is a little bit more. But I think, or at least that's how I want to read the case, I think that's a little bit where the case ends. And then you come into the different enforcement model, public enforcement, private enforcement. For me, a big function of this case, that there's two more, which are maybe a little bit less direct, but indirectly. One is the political argument. We are in the business of doing the best policy that is politically viable, and the political space is shaped by arguments, by pressure, by court cases. So it's yet another argument that you can use when you talk to politicians. You need to do something, and it needs to be at least like this, because otherwise you get in trouble with the court. The second thing, which from a European perspective I think is interesting, is that there's a lot of national cases where a lot of courts are asked, but what does it really mean, this Paris Agreement obligation, this human rights, environment, climate? And so at least this judgment starts to put a little bit of order. Maybe it's not perfect. Maybe you need to then look at it, maybe look at something else. Let's see if the European Court of Justice. But it puts a frame to say, yes, there is something about climate, and it's about reducing emissions in a way which is a little bit ambitious and a little bit measurable, let's say. And so it, rather than allowing a lot of courts to invent their definition of human rights, it allows to all of us to move a little bit together towards a common understanding of what's the legal dimension of climate actions in human rights. But going into due diligence, no, I think our directors are very clear. You can't sue people because
Pascal, can I jump in here?
Yeah,
I'm
of
so
course,
sorry.
of course.
Just to compliment, I know I've spoken a lot. One of the main issues now being debated, and I speak about from for example, questions that have arisen from my clients, is the following. what will be the impact of the current climate change litigation developments at European and national level when it comes to the national implementation of the new CSDDD, Corporate Sustainability Due Diligence Directive, which will in fact be transformative in the following sense. The Corporate Sustainability Due Diligence Directive will require corporates that are in scope to potentially have to deal with novel forms of civil liability at national level. They will have to introduce climate transition plans, which will take account of the requirements of the Paris Climate Accords. And because the CSDDD is based on an imposition of an obligation on corporates to engage in human rights impact assessments to assess foreseeable and negative human rights impacts, the development of European human rights law, which is the European Convention on Human Rights, and under Article 52.3 of the Charter, the minimum benchmark for the EU Charter of Fundamental Rights, creates a circle of control and a normative hierarchy, which will mean that even though the KlimaSeniorinnen judgment has a relatively limited scope directly by the convention, through the national implementation of the CSDDD and the national legislation which will be put in place to fulfill those requirements, we will then see for the future the increased horizontal application of human rights laws through the CSDDD. And this, I think, is a crucial aspect to take into account for the future.
Thank you very much, because I'll coming back to you, Luca, because indeed that was a bit the aim of my question, whether in fact the enforcement will not be even more efficient through the compliance duties that will be set through the CSDDD than by direct implementation. What do you think, Luca? Because you want, I'm not sure we can hear you, so.
How do you quantify it? Like, okay, we ask a big company to say you need to look at your footprint and your emissions and have a climate neutrality plan. Okay, you're an oil company, you need to say, okay, at some point I will not sell oil anymore. But, and okay, when you look at climate neutrality, more or less you can quantify that. For anybody else, how can you read from the fact that you need to have an ambitious climate policy for a government with a quantified target to derive there the exact amount of emissions that a company under the due diligence can be liable for under tort? I think any of this would be like, I don't think this court can make a finding on this.
Yeah, I've been told by compliance specialists that indeed the enforcement of the CSDDD might be difficult in practice. But of course, this soft law perspective, and of course, as president of the European Law Institute, I think soft law might be sometimes powerful. The soft law aspect may, you know, the fact that you have to do due diligence might have even a better effect. We had a questions, I think, by Isa Toussard saying, how will these enforcement take place? You mentioned, or was it Karen, mentioned the political perspective, and of course the court perspective, and Véronique Boyer said, okay, maybe the courts in Switzerland, the Federal Supreme Court may be asked to revise its judgment in light of the European Court's Human Rights Court's decision. If it does so, of course, it's an efficient enforcement, and of course, despite the parliament discussion and decision, the court is entitled to do so if asked to do so. The question will more be how the erga omnes effect goes on, and here I think at least it could be through compliance and these soft principles. I don't know, Kerem, to go back to you maybe. Do you think that enforcement of these views and judgment will be more thought in terms of hard law and court decisions, or what would be the strategy like from your organization?
Yeah, I mean, there are obvious negative impacts about climate litigation coming from the lack of victimhood of individuals. But now all NGOs around the member states have a legal basis to raise before national courts about state duties under international law to meet the standards of Paris Agreement and convention requirements. So in all those states, there are active NGOs working to realize the requirements of international law. So it will be used by them. One problem, of course, might be, it has also been discussed, this locus standi in national law. But if those cases are rejected by national courts, then it might give right to those NGOs to go directly to Strasbourg for lack of access to court arguments. So if national laws do not give rights to NGOs to raise those concerns before national courts, it might even open the way for quicker decisions from the European Court of Human Rights. So all member states will have to consider giving the right to the NGOs to go to national courts to raise convention-related rights concerning climate change. And I think this is a very critical and important takeaway from the judgment, and it will affect the approach of domestic jurisdictions. Otherwise, there will be a direct way to the Strasbourg court, which I guess not the intention of the court while delivering this judgment. So it might be seen another effect, erga omnes effect of the judgment.
A kind of indirect erga omnes effect linked to the Sanders law key for association NGOs. We have a further question, which is also interesting, but of course it leads us more to tort issues. But what Professor Weber from Zurich asked, what about the causality of omissions? Does the KlimaSeniorinnen case give any guideline in state cases comparable to corporate cases, RVE, for instance, giving percentages? And maybe that's also a perspective that is more private law oriented. But of course, in terms of causation for omissions, you might have the so-called hypothetical causation, causal link, which brings in some, again, difficulties. And Luca De Carli was saying there's no threshold, there's no numbers, and so on. Would that be a difficulty? Does KlimaSeniorinnen say something about that in a way that could be useful? I don't know who wants to say something about that. Not everyone at the same time, please. I understand it's a bit outside the core of our discussion, but I see Robert.
I can give it a go. I think, as you said, well, two things. First, KlimaSeniorinnen is about state responsibility under the convention, and it's formulated through the lens of positive obligations of states. And it introduces, in general, an obligation for states to put in place what we can call, and have been called in the literature, climate framework laws. So questions of causality based on emissions, lack of action, is not an issue which comes into play in the public enforcement level. What the court is looking at a picture of a structure. Does the state have in place a climate framework structure which fulfills the blueprint of the convention? It will not enter, at least that is what the court says, and I believe that is true, it will not enter into a granular assessment of the level of engagement by the states where potentially issues of causality will come into play. So I don't think one can hypothesize or analogize the sort of the private law conception of causality for emissions when it comes to corporate potential liability with this climate framework laws approach under positive obligations under the convention.
Thank you very much. I think this is also very, very clear, and it makes really sense. We have a further questions. We are getting slowly to the end of the time for Q&A, but Olivier Marder says, what is the effect on the relation of the European Court Human Rights and Court of Justice of the EU if under Article 52, subparagraph 3 FRC, the content of Article 7 FRC will have to be read in the light of the minimum standard of Article 8 Convention, as interpreted by KlimaSeniorinnen. Of course, this is a question asked by a Swiss, I mean, in Switzerland by a German lawyers. You can see that because you have only articles, and so, but does someone want to elaborate on that? What will be the relationship and the effect? And I see Robert or Matthias, maybe. No. Okay. Or Luca, do you want to? Yes, please. Thank you very much.
So there is this passerelle, this bridge linking the European Convention on Human Rights and the European Charter of Fundamental Rights, so on which the European Charter needs to be interpreted in light and take into account, and as a basis what Strasbourg said. So if you want, Luxembourg has to copy Strasbourg. I think what's interesting here, though, is the question of standing. So a lot of climate legislation in Europe is done at European level. It's in the form of regulations. We have a couple of directives, meaning that individuals will find it quite hard to pass the Plauen test to have a direct and individual concern in Luxembourg, in the European Court for Human Rights, so the European Court of Justice. So what I see a little bit more happening is that in national courts litigation for more climate action, there will be a bit of combination of arguments on, like, sue Germany and sue Italy based on German law, European law, and charter law. I try to throw everything in and see what sticks. That's for me how I see a little bit the development of this, and then we see how the whole system reacts and what will rise to the top in terms of preliminary ruling or exhaustion of local remedies. And as you say, the weakness of some member states that do not allow collective action by NGO will find themselves in Strasbourg very quickly. So that's a way of thinking about it. Do I need to open this door before it's completely fallen off by the interest?
I see. And if I pick from your answer and also on the basis of the re-elaborated questions by Oliver Marder without the articles, but with the content, do you think that the fact that the court stresses the importance of NGOs now in this type of litigations, will that also have an effect on other areas where maybe the collective perspective will be more emphasized, or is it just on these type of issues? Robert, if you want to.
I think you just hit on an extremely important point. I agree with everything Luca said. Let me just say one thing. The effect on Article 7 of the Charter is, of course, prima facie going to be quite substantive, ultimately. Article 7 of the Charter now has to be interpreted in light of KlimaSeniorinnen, at least where the Charter comes into play. And the Charter comes into play, for example, when member states implement EU law under Article 51.1 of the Charter. So implementing the EU Climate Act, in EU climate policy, to the extent it's harmonized, will have to be viewed through the lens. But your point is really, really crucial in my view, because what the court does by excluding victim status for individuals almost in its entirety, it thrusts climate change litigation into the hands of associations, which by definition will bring more general and abstract claims. So in other words, climate change litigation, instead of focusing on granular level of harm, where individuals actually litigate on the basis of granularity, it will be more general-based, more collective-based. And I'm not sure that is a good thing for climate change litigation moving forward, because again, it goes back to the nature of the problem, which is a multifaceted, multipolar, policy-oriented issue. It may push courts to take positions which will ultimately be positions which will put them in a great challenge with the separation of powers domestically. So the collectivization of climate change litigation through the lens of associations remains to be seen whether that is a good step moving forward.
Yeah, thank you very much. And I think that's almost also a good final sentence or statement, because indeed we could reopen the whole tort litigation aspect and whether that will then be left with more difficulties or not. And I think the European Law Institute will certainly have in the future again the opportunity to come back either through new decisions, because as we said, there are 6 decisions pending at the European Court of Human Rights linked to environmental law or to other instances, especially through our ELI project on climate justice. It is the time now for me to thank very warmly all our panelists today. This has been really an intense and very interesting discussion. Thank you very much. Some were here for the first time, some others like Robert Spano has come several times. Thank you really for taking the time here to spend your lunchtime with us to reflect and try also to help all our members and all those who will certainly look at the recordings later on how things may evolve. It might even be interesting to watch this recording in 2 or 5 years from now to see whether some of the fears or analysis have really taken became a reality, or whether things have changed, maybe also thanks to this discussion. So thank you very much to all of you. And in the name of the European Law Institute, I would like to thank also everyone who attended this webinar. If you need more information on the ELI project, you can go on europeanlawinstitute.eu, and of course stay in touch. We look forward to meeting you, maybe also at our annual conference from 9th to 11th October in Dublin. Thank you very much. Have a good day. Bye-bye.